I'm Mike Smith. I'm a ER doc at Oxnard in New Orleans, and I'm also the medical director of the SAEM Center there. Jeff Baker is in a core faculty at Louisville, and Marilena DiSilvio is an attorney along with Denise Dickerson in Ohio, where I'm originally from. And what we're going to do is a simulated deposition. There's no disclosures. This is something, as an ER physician, depending on the state, you're probably leaning towards probably a 70–75% chance you're going to be sued during your career. In the state of Ohio, they would give awards to people that were never named in a lawsuit. And it's something, even if it's something that sort of seems sort of frivolous, I'll tell you my story about what led up to this. It has an effect on you, and it's a long term process. We have an obligation by federal law to screen people. In most areas, that doesn't come with any protection from the risk of seeing those patients. So we're sort of stuck in a position that we have an unfunded mandate to screen patients for medical emergencies, but those patients can still sue you. And this is something, when I had my experience, it's something that doctors like to talk about and give advice on, but it's not necessarily always really well-founded advice. So in Ohio, before they have something called an affidavit of merit. So when the person goes to sue you, someone in the same specialty has to sign off and say that it doesn't seem like it's a frivolous case. So this was before that. So I saw a lady with a headache and I didn't refill her Percocet prescription. So she sued me for that. She was dropped by multiple lawyers. It was eventually dismissed. She went through the appeals court, made a complaint against my medical license, and she said it made her suicidal that I didn't refill her Percocet. This was still like 2 years, a 2-year process. So the point of all this is that this is a skill that can be taught, and simulation sort of helps do that nicely. So the way we do this, we take an EM physician volunteer, and the thing that you don't see during this presentation is we've allowed Dr. Baker to meet with his defense attorney, and she prepares him for the deposition in the same way he would be prepared in real life. So it's usually you get something like this, you make that face, you spend some time doing this. Okay. And we're using a case of a missed MI. So someone that died after an MI, Dr. Baker saw them and discharged them from the emergency department. All these cases are real cases. Dr. Baker did not see this patient in real life, but we chose cases that the ED physician won. So this is not like an insurmountable mountain, if you will. So, well, there's different variations we can do this in, but I've done it with a novice a physician, and one time we deposed our chairman. So we'll get into this. We'll do the deposition, then we'll have some time for debriefing and a Q&A. So I would just ask you to respect the process. We've never really had problems with it. I just ask you not to heckle during the deposition, and then use this as a chance to ask questions, the questions that you always want to ask but never get the answer to you, like how do you select people as a plaintiff's attorney, when you're looking at cases? So ask the attorneys questions like that. And then this is something that we can help bring to your institutions too, because again, this is a skill. This is a skill like putting in a central line, intubation, And you can do the skill poorly, or you can come at it pretty well prepared. So we'll go ahead and start. I'm going to get off the stage so I don't ruin the mojo.
Good morning.
Can everyone hear me okay?
My name is Marilena DiSilvio, and I represent the family of Mr. Peter Tiller in this lawsuit. Could you state your name for the record, please?
Jeffery Baker.
Dr. Baker, have you ever had your deposition taken before?
Yes.
Well, today I suspect will be very similar to your past experiences. This is a question-answer session under oath. My questions are not designed to trick you in any fashion. So, if I ask a question and you don't understand it, will you please ask me to restate or rephrase it?
Okay.
If you answer a question that I pose of you, I'm going to make some assumptions. Number one, that you heard me. Number two, that you understood me. And number three, that it's the best answer you can give. Fair enough?
Okay.
I will also be relying on your answer for the purposes of the trial of this matter, which is scheduled for December. So at any point in time, if you wish to go back and add to an answer, modify, edit, amplify, whatever you'd like to do, let us know and we will accommodate you to do so.
Okay.
And finally, to your left is Ms. Dickerson, your attorney. If at any point in time you wish to take a break and speak with her, let us know and we'll accommodate you in that regard as well. Okay, great. Could you tell us, please, what you have reviewed for the purposes of giving your testimony here today?
I reviewed the medical record.
All right. Have you made any notes of any kind?
No.
Have you reviewed any medical literature to refresh your memory as to the issues that arise with respect to the care of Mr. Tiller?
No.
Have you sent any text messages, made any blog posts, in any way interacted with social media regarding this case?
No.
At the time of the care at issue, did you send any texts to any colleagues relative to Mr. Tiller?
Not that I recall.
All right. With respect to the medical record, is everything in the medical record accurate to your knowledge?
To the best of my knowledge, yes.
Is there anything that you would like to edit, change, or modify with respect to your charting?
Not specifically. No.
Okay. Could you tell us, please, a little bit about your educational background, beginning with college?
Sure. College at UT Arlington in Texas, med school at Baylor, intern at Baylor, residency at Cook County, 12 years experience as an emergency physician in New Orleans, and now faculty at University of Louisville.
Are you board certified?
Yes.
Did you pass on the first attempt?
Yes.
And with respect to professional organizations, to which do you belong?
I may not list them all, but ASET, SAEM, AAEM, probably a couple of others I'm forgetting.
Those organizations promulgate guidelines. Is that accurate?
I don't know if they all do, but there are guidelines within those specialty organizations.
Are you familiar with the guidelines for the management of a patient presenting with chest pain to the emergency room?
Not specifically. I think several of the organizations may have those guidelines.
Does your emergency room have a chest pain protocol?
Not specifically, no.
Do you teach residents?
Yes.
When a resident asks you questions about chest pain or acute coronary syndrome, to which books or online references do you introduce them?
At the time of the question, it's usually not a specific text or online thing. Oftentimes we use the heart score, and then there's a very large body of work, so there's lots of things to choose from.
Okay, fair enough. At the time that you provided care to Mr. Tiller, who was your employer?
Ochsner Health System.
And were you acting within the course and scope of your employment with Ochsner Health System?
Yes.
Were you the physician responsible for Peter Tiller on the day of his emergency room presentation, July 25th, 2013?
Yes.
Was there anyone else responsible for the decision-making as it relates to his clinical care and treatment in the emergency room?
No.
Do you agree that a physician is not allowed to needlessly endanger a patient?
Yes, I think that's...
In other words, a reasonably prudent physician does not endanger his or her patient. True?
Yes.
And one of the responsibilities of physicians acting within the standard of care is to protect their patients. True?
I guess it depends on how you define standard of care, but
So I will tell you that standard of care, as it is defined legally, is what a reasonably prudent physician would do under same or similar circumstances.
Okay.
Using that definition is one of the responsibilities of physicians acting within the standard of care to protect their patients.
it is one of the responsibilities.
And there's nothing more important than the safety and well-being of the patient.
It is one of the considerations.
Can you tell me anything that's more important than the safety and well-being of your patient?
It's difficult to rank individual things. Safety and well-being is important.
Anything more important than safety and well-being?
Truthful, ordering the appropriate tests, communicating with the patient.
And that's all to ensure that you're protecting safety and well-being.
That is one of the elements of the patient-physician interaction.
And your job is to do no harm.
Correct.
Your job is to not discharge a patient with a life-threatening condition.
My job is to evaluate patients to determine the absence or presence of those conditions to the best of medical science.
And you would not let a patient with a life-threatening condition walk out your emergency room doors.
If I diagnosed a patient with a life-threatening condition, I would recommend that the patient stay.
Just recommend?
I can't force a patient to do something against their will.
Fair enough. Do you agree that time is cardiac muscle when it comes to a myocardial infarction?
If a patient's having an active myocardial infarction, yes.
All right. Okay. So, as an emergency room physician, as I understand it, you have one of two choices. You either admit the patient or discharge the patient.
Let's see, I could admit the patient, I could discharge the patient, I could recommend admission, I could recommend discharge, the patient may choose otherwise.
You can recommend admission, you can recommend discharge.
There's observation, yes, also.
And what do you mean by observation?
It's a kind of a process of the patient's not fully admitted to the hospital, it's considered an outpatient stay. They may stay in the emergency department for observation or in a designated ward for observation.
Like a 23-hour observation unit?
That is one type of observation unit.
Okay, so you have an observation unit, admission, discharge, and recommendations for all three?
Yes.
Okay. And with respect to your job as an emergency room physician, when a patient presents, you must arrive at a differential diagnosis.
Objection. You can't.
For a patient presenting, I'm sorry, repeat the
Sure.
question.
Every patient you see requires a differential diagnosis.
I don't know if I would say they require differential diagnosis. It is a tool I use in the evaluation of many patients.
How do you define a differential diagnosis?
So depending on the presenting complaint, it's a tool I use, so where I consider different diagnoses that the patient may have depending on their presentation.
And you use that tool with every patient you see?
Most patients, I would say.
Are there occasions where you do not arrive at a differential diagnosis?
There are patients where I don't need a differential diagnosis to treat the patient.
And describe that type of patient for me.
If a patient comes in with their hand cut off, it's kind of obvious.
Pretty obvious. Okay. So in a patient with a non-obvious condition, you would use the differential diagnosis as your tool to make decisions about disposition of the patient.
It's one tool I use, yes.
All right. And what you do with the differential diagnosis, at least as I understand it, is you arrive at your most life-threatening diagnoses at the top of the list and come down to those that are less life-threatening.
That's one way to do it. So you can also list the differential and most likely to least likely, depending on the presentation and the data available.
If there is a life-threatening condition on the differential, would you agree that that needs to be ruled out before the patient can be sent home?
It depends on what you mean by rule out, I think.
Okay. How do you define rule out?
So rule out is not excluding with 100% certainty the presence or absence of a disease. It's evaluating a patient with the data and tools available to me at the time to make the possibility of that disease so low that no further testing is needed at that time.
Fair enough. So then a patient who presents with chest pain, who walks out the emergency room door having been treated by you, will have myocardial infarction as low on the list as the least possible.
It may not be the least possible, but if I considered myocardial infarction in a particular patient, then my testing is targeted at detecting the presence of myocardial infarction so low that there's no further testing is of benefit to the patient.
Fair enough. And the testing that is done for these patients includes serial EKGs,
In some cases, yes.
serial troponins,
In some cases, yes.
with troponins done every 6 to 8 hours?
It varies from place to place. I use every 3 hours in my practice.
And do you have any literature to support the practice of every 3 hours?
There is substantial literature out there. I don't have it in front of me, so I can't review it right now.
All right. And is there literature to support troponins being done every 6 to 8 hours?
I'm sure there is some out there, too.
And why do you choose an interval of 3 hours as opposed to every 6 to 8?
It is my practice to do that, and the practice that I've used through developing years of experience tells me that 3 hours is appropriate for many patients.
Okay. And with respect to serial EKGs, what is your practice in terms of obtaining those in a patient who presents with acute coronary syndrome?
Typically, an EKG is obtained during the initial presentation of the patient, often in triage, or if it wasn't done in triage, then I order it when I see the patient, and then usually an EKG is obtained when we draw the next troponin, so 3 hours or whatever time.
Okay. And tell me what the purpose of the medical record is, please.
It has many purposes.
Tell me what the purposes are for you.
So it's a communication tool for other providers is the most important thing, I would say.
And does it capture what you have done for the patient during the course of your interactions with him or her?
I think it is a record of some of the things that are done. It's not an exhaustive tomb of every moment of the encounter.
Certainly EKGs should be part of the medical record.
Yes.
Certainly radiology reports should be part of the medical record.
Yes.
And certainly the timing of intervention should be accurately noted on the medical record.
One would hope. So obviously it's more important for me to treat a patient than document. So sometimes documenting is secondary to that, and obviously there's technical issues. Maybe I can't document at that time, depending on if the computer's not working or I'm not sitting in front of a computer.
Okay. I'm going to mark as Exhibit 1 the medical record for Mr. Tiller,
Okay.
and I see that you have it in front of you.
Yes.
The medical record reflects that Mr. Tiller presented to the emergency room on July 25th at 2:03 p.m. Do you see that?
I see that, yes.
This is the month of July. Were any residents involved in the care and treatment of Mr. Tiller?
No.
According to the triage information, the patient complained of chest pain that started last night, went to work, got worse, pain mid-sternal radiating to jaw and neck. Do you see that?
Yes, that's documented, likely from a nurse.
And your responsibility as an emergency room physician is to review that which the nurse has charted, not only in triage, but also in her evaluation of the patient.
I often review those if they're available to me at the time of treating the patient.
This is an electronic medical record?
Yes.
Is there any reason why an electronic medical record would not be available to you during the patient's stay in the emergency room?
Certainly. I may be caring for other patients at the time, not sitting in front of a computer, or there may be technical difficulties, and I can't view the record at that time.
Certainly you have to input into the medical record too.
Yes.
And when you do your electronic entry, certainly you can look back and see what care preceded you.
If it is available to me, yes.
All right. And if it is available, certainly you would review it.
That is my usual custom at that.
Okay, great. Can you tell me, please, whether or not this pain was worse with exertion?
I'm going to have to refer to the medical record.
Please do.
I'm going to have to refer to my documentation.
Certainly.
And there's nothing to suggest that it was worse with exertion.
Okay. What did he do by way of employment?
I don't recall.
Is it significant to you as the emergency room physician to inquire as to whether or not the pain worsened with exertion?
It can be. It's not always necessary.
What is the significance, if any, of chest pain that is worse with exertion?
Unfortunately, I think it depends on the individual patient. It can be a sign of an MI, but plenty of patients have MIs that without exertional pain. So
All right. Can we agree that pain with exertion is a sign or can be a sign of ischemia?
Are we agreeing that it can be or
Yes, that it can be.
It can be, but it may not be.
Fair enough. Can we agree that pain mid-sternal radiating to the jaw can be a sign of an MI or ischemia?
It can be, but it may not be.
Okay. Can we agree that pain radiating to the neck can be a sign of an acute myocardial infarction or ischemia?
Again, it can be, but there are all of these entities that we've just discussed, all these symptoms we just discussed have many things that can cause them that aren't MIs. So
When you hear of these symptoms that Mr. Tiller had, do you begin the process of including an acute myocardial infarction on your differential?
it depends on the patient, and in this case, I did.
All right. So acute myocardial infarction or ischemia was on your differential for Mr. Tiller?
Yes.
Okay. Donna, a nurse, 9 minutes later, writes, upon arrival, denies pain, complaining of shortness of breath, rapid respirations, alert, encouraged continuously to answer questions, eyes fluttering, tremors at times, not following directions, slow speech. Did I read that accurately?
Yes.
Do you have a memory of whether or not you reviewed that entry by Donna?
I don't recall.
Do you have a memory at all of Mr. Tiller, individual from the medical record?
Not specifically, no.
Okay. Is all of your testimony about your care and treatment then from the charting?
The charting is the starting point, I think. As questions are asked, I may recall other details of the case, and then there's how I practice medicine.
Have you had an opportunity to review these records prior to today?
Yes,
On how many occasions?
once or twice.
For how much time?
I think the first time about an hour, and then 15 minutes the second time.
Have any memories triggered for you in your review of the records?
Not specifically.
All right. And today's deposition, obviously you knew I was coming.
Yes.
You received notice and had an opportunity to prepare with your attorney.
Yes.
During the course of that time, did you have any new memories arise about Mr. Tiller?
Not specifically, no.
Are you aware that Mr. Tiller died after he left the emergency room?
I am now, yes.
All right. When did you first come to learn of that?
I don't recall.
Did you do any investigation after you learned that fact in terms of going back, reviewing the charting, doing any literature search then at that time?
I'm sorry, that was a long list of things. I don't recall specifically.
Okay.
I didn't.
What, if anything, is significant about Donna's description of the patient as noted on July 25 at 2:12?
The only significant thing I can draw from that is that Donna documented that at 2:12 p.m. I'm not Donna. I didn't see the patient, so I can't draw any conclusions from that.
Okay. Let me ask you some specific questions then about what she charted. A respiratory rate of 24. Is that an elevated respiratory rate?
Yes.
Can that be a sign of an acute MI or ischemia?
It can be, but it's very nonspecific. There are lots of things that cause an elevated respiratory rate. MI may be one of them, but there are many other things that are not serious that can cause an elevated respiratory rate.
Okay. Shortness of breath. Can that be a sign of an acute MI or ischemia?
It can be, but there are many things that shortness of breath could be a sign of.
So as we look at page 1 of the medical record, the following can be symptoms or signs of an acute MI or ischemia. Pain, mid-sternal, pain radiating to the jaw, pain radiating to the neck, an elevated respiratory rate of 24, and shortness of breath.
Yes.
Is that a question?
It sure is.
So
Do you understand the question?
Could you repeat the question?
I can. Did you understand the question?
I don't think so, no.
Okay. Did you understand the question before Ms. Dickerson said she didn't understand the question?
I was trying to follow along, but it was a very long list of things. So
Okay. With respect to the first page of the medical record, would you agree that the following can be signs of ischemia or myocardial infarction? Pain,
can we go one at a time?
certainly.
Go ahead.
Mid-sternal pain.
It can be.
Pain radiating to the jaw.
It can be, but there are plenty of things that cause jaw pain.
I understand. I just want to know which ones can be associated with myocardial infarction or ischemia. If you can answer that question, that would be great.
Okay.
Pain, mid-sternal.
It can be.
Pain radiating to the jaw.
It can be.
Pain radiating to the neck.
It can be.
Elevated respiratory rate of 24.
It's a non-specific vital sign, a non-specific symptom. It can be.
Shortness of breath.
It can be.
All right. What about eyes fluttering?
I have probably taken care of someone that I've diagnosed with an MI whose eyes have fluttered. So
And what about the fact that this patient weighed 99.791 kilograms?
I've had plenty of patients who weighed less with MIs and plenty of patients that weighed more with MIs. So at the time of the evaluation, it doesn't really play a lot into it.
Was he morbidly obese such that it was a risk factor for coronary artery disease?
I don't recall. Looking at 100 kilos, I don't have his height in front of me, so I don't remember how tall the patient was.
Fair to state that at the time you saw the patient, you did not know whether or not he was obese such that it was a risk factor for coronary artery disease.
Yes.
Okay. Now, Doctor, see if you can help me with the times. The patient was admitted or to the emergency room or presented to the emergency room at 2:03 p.m. Then there's labs that were performed at 7:41 a.m. Can you help me understand how the labs were performed before the patient arrived to the emergency department?
I can try.
Okay.
So I'm not an IT professional. I don't recall the specific date, but it appears to me that some of the documentation was performed after the patient presented. Specifically, it's page 1, 2, 3, 4. The EKG was done at 7:22 a.m. And our documentation was done many hours after that. So again, I don't recall. Maybe the computer was not working, or maybe it was a busy day.
Emergency rooms can be particularly busy.
They can be.
How many patients do you typically care for during your shift in an emergency room?
It depends on the length of the shift. Probably a fair number is somewhere between 2 and 3 an hour.
And on this particular day, can you tell me what shift you were working?
I don't recall specifically. It appears to be a day shift if I was there at 7 o'clock in the morning.
And that's the part where I'm struggling. There is documentation from 7 o'clock in the morning until 1:30 in the afternoon in terms of events that transpired. But the patient, according to the triage, nurse's notes, had not yet even arrived to the emergency department.
Again, that's, I think we'd have to ask the triage nurse.
Okay? And obviously, you have an IT department that's in charge of your electronic medical record?
Yes.
And my questions would be best directed then to that department as it relates to this charting.
I suppose.
Okay? Then there is a note by you. 60-year-old male. Is his age a risk factor for coronary artery disease?
Yes.
Complaining of chest pain, shortness of breath, nausea, heartburn, and altered sensorium. What testing did you do to assess his sensorium?
His sensorium, specific testing for that, I checked labs, we obtained an EKG, he had a chest x-ray and ABG.
And is that for sensorium?
Those lab tests were for this patient at his time of presentation, including his altered sensorium.
And how do you assess, what are the tests you do to assess whether or not sensorium is altered?
That's just, an objective finding on the initial physical exam.
Do you ask, are you alert, do you check to see if the patient's alert to person, place, and time, or what do you do?
So I do. So I ask, do they know who they are, where they are, what day it is?
And to what degree was his sensorium altered?
So his complaint is altered sensorium, so that's what the patient says.
All right.
My findings on the physical exam is the patient was oriented ×3.
Okay. As it relates then to what the patient has told you, you know that his age puts him at risk for coronary artery disease, and that he has chest pain, shortness of breath, and nausea, as well as numbness and jaw pain, all of which can be associated with myocardial
And
infarction.
Other things that it could do, yes.
At the time that you heard the patient's complaints as articulated by him, did you have myocardial infarction in your differential diagnosis?
It was one of the things I considered, yes.
What else was in your differential diagnosis?
For this patient, it could have been anxiety, it could have been gastritis or heartburn, he could have had aortic disease, could have had pneumonia. Just a few of the things. I'm sure there are more.
What aortic disease were you considering?
You could have aortic dissection.
Of the list that you've just provided of your differential, what are life-threatening conditions?
Certainly acute MI, aortic dissection, and the patient has some infection.
Anything else?
Gastritis occurs on a spectrum. It depends on if he's bleeding to death or not, so it's a possibility.
Okay. What is ROS?
That's review of systems.
And how does one do a review of systems?
It varies from patient to patient. So normally, the review system can be, it can just be a list of questions. Sometimes, as I'm asking the patient's history, they volunteer elements of the review systems, or I may go back and ask them specific questions.
With respect to this patient, the blood pressure on the right and the left were different, true?
Yes.
With a systolic difference that is significant, true?
I don't know that it's significant. It's less than 20 points or right at 20 points.
Do you consider that significant or not?
In this patient, no.
Why not?
He didn't have a dissection, so after I evaluated the patient, I decided that the possibility of him having a dissection was low enough that it didn't make a difference.
Do you agree that where there is an arm-to-arm difference in systolic blood pressure, that can reflect plaque?
It depends on where the plaque is, not necessarily.
Have you read ever that a difference in arm-to-arm systolic can be a risk factor for coronary artery disease?
No.
Okay. As it relates to the charting, doctor, can you show me the EKGs that you obtained?
So there are no EKGs provided with this medical record.
Why not?
You would have to ask whoever provided you with the medical record.
There should be, right?
That's typical of the course. Again, I think you would have to talk to medical records. So.
You interpreted the EKG, at least according to your charting, as a left axis deviation and nonspecific T-wave changes.
That's what's documented, yes.
That's not normal, true?
And it also says normal sinus rhythm. The full interpretation is NSR, which stands for normal sinus rhythm, left axis deviation, and nonspecific T-wave changes.
That's not normal, true?
I don't have an old EKG to compare. Maybe it is in this patient. So I can't really say that it could be abnormal. It may be normal for this patient.
Well, doctor, let me ask you this. This patient's in the emergency room with signs and symptoms of an acute MI, and what you're telling me is you're going to just assume that this EKG is normal because you don't have a prior strip?
I can't agree with any of that. I don't know that I don't think he had an MI based on my evaluation. So
Patient safety is first, right?
it's one of the things that I consider when evaluating a patient.
Patient safety requires you to interpret an EKG appropriately, right?
Yes.
And we don't know if you interpreted it appropriately because we don't have the EKG.
No.
Objection. Go, you can answer.
True?
I interpreted the EKG at the time I evaluated the patient, and that's my interpretation of the EKG.
But we don't have the EKG to compare your interpretation to.
I don't have an EKG to look at right now, no.
And what you're telling me is that for the purposes of your assessment of Mr. Tiller, you concluded his EKG was normal.
His EKG was not consistent with an MI.
That's not my question. Was it normal or abnormal?
I don't know that I can say whether it was abnormal or normal without looking at it today. So at the time of interpretation, my interpretation is as documented in the chart, and I decided that I was evaluating him for an MI, and this was not consistent with an MI. Whether it's abnormal or normal, I can't really say.
So it could be normal, it could be abnormal.
Sure.
All right. Can you show me his chest x-ray, please?
I don't have it. It was
Do you-
not provided to me.
Is there a report of the chest x-ray in the medical record?
For the chest X-ray itself, no, just my interpretation of the chest X-ray.
Okay. And you interpreted that as normal, too?
I interpreted the chest X-ray as negative for pneumonia and negative for CHF.
Was it normal or abnormal?
It was, all I can tell you is there was no pneumonia, there was no CHF.
So-
That's my interpretation.
Fair to state, we don't know if it was normal or abnormal.
Objection asked and answered.
The patient had no pneumonia, no CHF. That's all I can say about the. That's all I can say about the.
Let's see if you can answer my question. So you don't know whether it was normal or abnormal?
Objection asked and answered.
The patient had. I don't know if I can answer that question. So
You don't know. I mean, that's,
Yeah, sure. My interpretation is he had no pneumonia and he had no CHF.
okay. So in this patient with age of 60 and a male, both of which are risk factors for coronary artery disease, right?
At his age is sure. Yeah.
And his sex, male gender,
Females have coronary artery disease also.
higher risk in males?
I don't know the current data, but I've diagnosed plenty of women with MIs.
I don't doubt that you have.
Yeah.
I'm talking about this gentleman in whom you didn't diagnose an MI. Is he at higher risk than a female counterpart for coronary artery disease?
I don't think I can answer that based on what I have in front of me.
Okay. So a man, 60 years old, in whom you don't know whether or not he is obese, who has chest pain, shortness of breath, numbness, and jaw pain, whose blood pressures in the right and left arm are different. We don't have the chest x-ray that you relied on in part to discharge him, and we don't have the EKGs that you relied on in part to discharge him. Is that fair?
We don't have the physical EKG or the physical chest X-ray, but we have my interpretations of the chest X-ray and EKG as a board-certified emergency medicine physician.
In retrospect, knowing that he died shortly after walking out of the emergency room doors, do you believe that he had an acute event, myocardial infarction, evolving or occurring at the time that he was in the emergency department?
Objection. Vague.
Could you restate the question?
Sure. Do you think it's pure coincidence that he walked out of your emergency room doors and died of a myocardial infarction?
Objection.
I'm not certain what you mean by coincidence, so.
You don't know what the word coincidence
I know
means?
I know what coincidence means, so I can't apply that to this.
You can't apply the word coincidence?
So I can only see the patient who was there in front of me in the emergency department at that time. I don't know what happened after he left.
He died. Was it a coincidence that he died after walking out of the emergency room?
Objection asked and answered.
I don't know.
Okay. You want to stop here?
Mike has cut us off.
Yeah, but you want us to stop and talk?
Yeah. Okay. Good times, good times.
Has anyone in the room been deposed before? How was your experience?
Similar. Good, similar.
His answers were great, right? I mean, he was very well prepared. There's a big difference between a very well-prepared witness and a not well-prepared witness. On the iPad here, there are 3 students from a local high school where I live in Ohio. And they have spent 2 weeks with me watching videos of depositions of very unprepared witnesses who admitted negligence, who admitted that their negligence caused the injury complained of, because they weren't prepared and they hadn't reviewed the charting. This is a wonderful example of someone who knew that chart inside and out, what the frequency of the troponins was, the fact that there was no EKG, the fact that there was no chest x-ray in the chart, distinguishing between admitting to a generality and acknowledging that that generality doesn't always apply. I mean, it was really well done.
And there were a number of times, depending on the witness that I'm representing, I knew he had these. I knew he had it covered, and I was confident that he was going to refer back to the record and pull on his knowledge and his experience. And so I could have objected a whole lot more if I was more concerned, and I would have been in my right to try to throw the lawyer off a little bit more. But in this case, it wasn't necessary because he was prepped so well. But it's just, as you're going through your career, it's going to be different every time. I mean, you're going to have some that are nice, and Marilena's a nurse by training, even before she went to law school. So she knows more than a lot of lawyers would know. And you guys just got to remember, you're the smartest person in the room. I mean, they may have a little bit of, what I call a little bit of knowledge, enough to be kind of dangerous. They think they know, and either they've read one book or article on it, or they've got an expert who has told them something. Doesn't make it true. I mean, you guys have been trained. You guys have the education and the experience, and it's really important, and that's, you know, part of what we talked about. It's just like, go back to what you know. Be confident in your experiences and what you have done to get where you are.
I'll say that for me, some of the questions, and the questions I thought were good. Occasionally, you know, I teach residents and medical students, and something that Marilena asked was kind of wrong or could have been better, and my initial gut reaction is to teach her what is right. So instead of just answering her question, and I can bloviate as good as any other academic physician, and I'm tempted to do that. But I was prepped to just answer the question, and if the question was bad, just say, hey, the question was bad, you know.
Right. If they don't ask the right questions or they have a misunderstanding, and he did a nice job, if she wanted him to use a term or a phrase, he defined it. He didn't let her define what the phrase or what he was talking about or what she was asking about. So he controlled that narrative. So we're sure that down the road, the question that they're going to put up, because they're looking for a soundbite where somebody says, oh yeah, I killed the patient. They're looking for something, and they're not going to get it because the question wasn't proper, or the question, you know, was frankly corrected to some extent by the witness. But, you know, rule number one is you're there to answer their questions. And if they don't ask the correct questions, or they have the wrong impression and aren't smart enough to ask you to explain it, you got all the time during your case to explain why they're wrong.
Okay. The deposition, you're not going to win your case at deposition. That is not the time to win. But you can lose it. The time to win is at trial, which is very, very hard, I think, from a defense perspective to understand, because the plaintiff always gets to go first. The plaintiff has the burden of proof. So the defense doesn't have time to really start to shine until day 3, 4, 5 of trial. And by that time, it's likely that you're very frustrated that you haven't yet been able to explain. But the fact that you didn't explain at deposition is your safe haven, because you now have the opportunity to put on your defense without that lawyer being prepared for how you're going to teach, what you're going to teach, or how you're going to explain if that lawyer has failed to ask the right questions. So you never educate at your deposition. And it also gives that lawyer fodder for additional questions. So Dr. Baker did an amazing job of not answering more than he had to answer.
What questions do you guys have? So one thing, even as a physician, I've never been deposed for a med mal, but just for treating physician stuff. I've been sued. But you often don't get to ask real med mal lawyers questions. So if you have any questions, this is a good opportunity for you to do it. So.
To go back and
Because you know what my question would have then been? Isn't that great? You reviewed everything to prepare for your deposition when your neck's on the line, but when my patient was in your emergency room, you didn't review a darn thing.
And it could
Right?
have been years and years and years before. I mean, sometimes it takes 3, 4, 5 years for the lawsuit to come up.
And the reality
Things
is,
change.
as you read every day, I mean, you're going to come across articles, but not specifically relative to your lawsuit. And not because there's anything bad, but because of the potential for a nefarious twist on that. If I were sued for legal malpractice, I would go research the rules immediately. But my lawyer would tell me not to, because there can be a nefarious twist to it, the inference being you didn't know in the first place that you had to go brush up.
When you discuss these cases in our own internal event and, slap on the peer review confidentiality, what you know, how do you guys look at actually discover what you guys?
Okay, that's an excellent question. I take the position that if you just slap on peer review, you might have a problem down the road. The statutes, depending on what state you're in, require that there's a defined peer review committee. It requires that certain people sign certain things. I would look at each statute, but I would be wary of just slapping peer review on there. Your legal department in your own institution should be able to help guide you. If you have routine M&Ms, somebody has taken great measure to make sure that your M&Ms are protected. But in terms of emails or sending something to someone who's not on a formal peer review committee and just calling it peer review, that I would not do.
Is that mic live?
It's the latter. It's not how to not get sued, because there's plenty, in my residency, both when I trained and now, we teach our residents, how to chart defensively, and then of course you don't practice medicine defensively. You don't tell people you're practicing defensively, but we all do that. And this is how to conduct yourself once you're sued. So and again, it happens. So. Yeah, I think this is easy to take wherever. We're actually doing this in University of Louisville in 2 weeks. So I'm doing the variant that Dr. Smith mentioned, where I have one of my senior residents who's not going to be very well prepared. And then I have one of my experienced faculty who is going to be very well prepared. And as a nice comparison and contrast, none of you guys know me, but I think it's quite memorable when your peer is up there or you're up there, and it probably sends home a nice message that you might remember for some time. So. Yeah, we missed part of it, but
Can you come to the mic?
Yeah.
Would that be okay?
There's-
There's background
Yeah.
noise,
Yeah.
and it's difficult for us to hear you.
Yeah, it's not even on.
That's not on.
Are you asking if you don't have a lawyer, you don't have an attorney?
A lawyer
Yeah.
in the med school or your conference, right? So if you have content knowledge, what it would be in a court. So if you create facilitator guide, like just one page, for any attending, just read and this is point for debrief. This is a point of learning, how to confederate. I don't know in your simulation is have a confederate like a judge in the scenario or not. So is would be applied to anyone.
Yeah, yeah. I think it's difficult. One of the things that makes this so real is that these are attorneys, and that's how I think we've achieved kind of a high fidelity simulation on this, and doctors think they're good at everything, right? So I know I am. So if I were acting like a lawyer, I'm going to act like the best lawyer ever. So, and that's the problem with it. So
And it'll be everything you learned on
yeah,
LA law.
yeah, and I'm a horrible lawyer, I'm assuming. So,
There's some options to do it. Some people are MDJDs, sometimes a compliance officer who's an attorney. The hospital may set it and do something like this, but I think it works really nicely when you've got people that actually do it. When I first met Marilena, the firm that she was with was retained by the hospital, right?
Correct.
And with their contract with the hospital, they had some educational time, so that's how we worked around not dropping $500-600 an hour to put benefits on. So.
The scariest part about this whole process, and I would tell you that I'm fortunate not to have gone through this process yet, but I realize it's coming. What exactly happens with the deposition? Can you just walk me through, give a piece of paper, then what happens?
So once the deposition is taken, did they all get that deposition? No. It's reduced to a booklet form, and everything that's said is transcribed by the court reporter verbatim, including the ahs. I mean, everything is verbatim. That transcript then gets sent to the experts that are in the case, and the experts read and review the transcript and take from it that which supports the particular expert's position. Ultimately, at trial, if it gets to that point, that transcript is used to impeach, if that opportunity arises, the physician in an effort to challenge credibility. Some of the questions that I asked aren't really medical questions, questions about safety and well-being. That's all designed to create among the jurors a heightened sense that, boy, this is really important stuff and rules must be followed, to make it easier, from my perspective, for the jurors to conclude that rules have been broken, right? So that isn't used through the deposition, but I want to get those admissions now to be able to then use them at trial. So it has sort of a threefold process, or threefold significance. It goes to the experts, it can be used to impeach, and you attempt to elicit admissions that you hope contribute to the theme that you ultimately want to demonstrate at the time of trial.
And some of those questions are just designed to try to create an overall negative impression of the doctor or the facility. Or, if you're representing a corporate defendant on something, you get these, don't you have a moral duty questions. And they're questions that don't have a good answer. I mean, you agree people need to be kept safe. Well, of course I do. How else can I answer that question? Or don't you have a moral duty to create policies and procedures that protect, unborn children? Well, but we do that. So that, part of it is that overall, I don't want to say cheap shot they might take to try to create a negative, but that's what they might do. And then they would, and if you're deposed, you would also get that transcript. You will have the opportunity to review it, and you will have opportunities to discuss it with your counsel. And hopefully you're not impeached at trial, because that means you changed something, and that's not a good place to be. But that sets kind of the tone of what's going to happen and where they're going to probably go with you.
And the other thing that happens with that transcript is some of the questions are designed to allow me to ask for more depositions. the IT piece, it allows me to explore, to determine
The
what
triage
what more do I need? What more can I legitimately ask for that is relevant or likely to lead to the discovery of relevant evidence?
I believe that you might high fidelity, including a psychological fidelity, right? High fidelity, including psychological fidelity. So my question is, how do you have any backup plan for psychological effect, like a crying, depressed, or because this scenario is affect to emotions a lot. It's stressful. If you make it real, you have a lawyer, real lawyer, you're like on the court. So share me what do you have any backup plan for that? Or if you implement already, what happened for your residency?
Well, when we do simulations in general, we sort of, I pre-brief them why we're doing this. And I say things like, we're not doing this, especially if you do something like this on a stage, it's very easy to feel during the simulation, like if it's a resuscitation or something, that the instructor or the facilitator is trying to mess with you. And we sort of explain that in the pre-brief. Marilena made the first person almost cry.
Oh, that was awful.
Yeah, so
It's not fun, and you won't
not fun.
like it.
And then you go over that in a debrief, not just like for the audience, but you would have a debrief among the people participating afterwards.
Do you have a question?
It can happen.
But that was the difference between an experienced, prepared witness, and, I mean, this resident was lovely, but she was maybe a first-year resident who did a remarkable job for being a first-year resident, but she did well up a little bit because it can be, this, we try to make it as real as possible, and it can evoke a number of emotions.
I was uncomfortable most of the time up here. So.
But you didn't show it at all.
There's inexperience. So we would do this, I did this with my former chairman and chief resident was another example. So there's differences in experience, but we still allow them to prepare. So they're still prepared, even though, like, the chairman has been through dozens of depositions, but then an expert witness. So he was very comfortable, like, not getting backed into a corner about, this is your job to rule out disease. He put the brakes on that, so we don't truly rule out disease. We evaluate previous probabilities and come up with post-test probability.
And most of your institutions or your insurance providers will give you a lawyer that you can say to that lawyer, please cross-examine me, or have someone from your law firm cross-examine me and do this in preparation for lawsuits.
And even just before we came in, I asked Denise, tell me again, what am I supposed to say when standard of care comes up? So, do you have a question? I'm so sorry.
It's just more Tom Brown, the residence director Austin. I want to say something like Sean learned how you guys set this up. So you had the less prepared person do your post first, and when you said unprepared, you said you did prepare. So what was the preparation for the novice learner at the end?
That's what I was trying to make sure we differentiate. So they were novice, but they were prepared. We still allowed them to meet with their defense attorney and go through the process. So it would just be the difference between someone getting sued right out of residency versus someone being sued, into a 30-year career that has been through the process.
And is there a case bank or a set of teaching points available online or somewhere where I can try to create? We have our own attorney for our group, so I can have them come do it. But I'm asking to do like a work. Is there a resource that I can use to get a case and get some teaching points that I want them to walk away from?
I'm always free. Like I've shared videos and materials. We should eventually publish with the Meta portal or something.
Yeah.
We haven't
I get in touch with Mike. This is his brainchild, and yeah, we should definitely put it up on MedEd. I think that's great. And I will say, you know, you talk about the novice resident. I am, and as you know, I've been sued but not deposed. I used to practice in Louisiana, so we had medical review panels, and so you just had to write a statement. And I put off writing my statement and talking to my attorney as long as possible when I first started getting those, because I didn't want to deal with it. So, and I think that's what a lot of younger physicians will do is, I'm not going to deal with this until I have to deal with this. And now that I've been sued a couple of times and I'm older and wiser, supposedly, I kind of just do it as soon as I can. I talk to my attorney and have a conversation, as opposed to before, and with a lot of the inexperienced people, it's the attorney's nagging me, so trying to get me to say something, you know, try to give my statement or whatever, or prep for a deposition. And now I'm like on the phone with my attorney, you know, the next day saying, hey, what can we do? Let's get this knocked out. So,
And
that's,
it removes the anxiety
Yeah,
of having
yeah.
that hang over your head. You know, you attack it right out of the box.
We start with learning objectives, I won't even know how to write a learning objective.
Yeah, yeah.
Take lots of comments, and when you put this session together, make sure you teach these 5 points.
Yeah, yeah.
I will look at that.
Can you talk about the process, how it starts with the 180-day letter, what's standard?
That is an Ohio thing. I don't know if it's in every state. In Ohio, a plaintiff has 1 year from the date that he or she knew or should have known of an alleged negligent act, or 1 year from the date of the last treatment with the physician for the injury complained of, within which to file a lawsuit. That can be extended by law 180 days by sending a letter to the provider saying, we are taking advantage of Ohio law. We need another 6 months to be able to make a decision,
To investigate.
and decide whether or not we're filing a lawsuit. The plaintiff is duty-bound in Ohio to obtain an affidavit of merit from a physician that says, yep, there was a breach in the standard of care, and that breach in the standard of care caused injury and or death. That affidavit must be attached to the complaint. There is a way to ask for additional time, a motion for leave to submit your affidavit of merit. That complaint is then sent by certified mail to the defendants on the list. Defendant gets the envelope, big envelope, and it typically says you have 28 days within which to answer. It is very important, no matter what state you are in, if you get that envelope, if you get the 180-day letter, to submit it to your risk department, your insurance company, because that triggers certain things with insurance of when you knew of a potential claim. When you then get the answer, or the complaint, very important that you get it to risk or to your insurance company, because if you don't file an answer, that can be a very big problem. The plaintiff can move for something called default judgment, which is, you didn't answer, you're wrong, we win. I'm making that very simple, but I make it that simple and make it that severe because that can happen. Once an answer is then filed by your lawyer, we're off to the races, meaning you're going to next have an appointment with the judge where the judge will set forth a schedule, a homework assignment list. When is it that you have to submit expert reports? In Cleveland, expert reports are necessary. In Columbus, they're not. All you have to do is identify the expert. So it varies not only state by state, but also within the state. When do you have to submit those? When do you have to complete depositions? When will we meet again with the judge to check to see where we are in the progress of this litigation? And then we also set a trial date and a date for a conference with everyone, the plaintiffs, the defendants' representatives, not you, but your insurance carriers, to meet with the judge one last time prior to trial to see where everyone is in terms of the possibility of settlement or resolution, or being sent for alternative dispute resolution by way of a mediation or an arbitration.
Would you say at the 180-day letter part, is it fair to say that it's pretty broad about who that letter initially can go to, you walk past the room.
Everybody
letter-
in the record.
That letter is generated by fear that the lawyer's committing malpractice, right? Because if you don't send that 180-day letter and you miss the statute of limitations, then the lawyer's committed malpractice. So lawyers who are investigating cases will oversend rather than undersend with the thought, I may never need to sue this person, but I'm covered in case I do.
You may get the 180-day letter, but when you're thinking, I didn't take care of this patient really, then you never hear anything again.
Anything else?
Questions?
Is there a place where we can learn about different states' requirements or whatever? Because I'm looking from state to state, I would learn the difference.
How did she learn state to state?
So one of the easiest ways is to go to your risk department or your in-hospital legal department. I would say Google, but I can't guarantee that it would ever be really accurate, and I don't want to send you to the law books to look at the statutes, but somebody might have already prepared in your office sort of a MedMal, or in your hospital MedMal 101 sort of booklet that just lays out what the state requirements are.
But that would be for that state, or any states they operate in. If you're considering relocating to another state, then you're going to have to reach out to that state to find out. Your risk management people would know, and you may not want them to know you're considering leaving either. So, yeah, I mean,
But
and you
you're
can
in-
always call and ask, somebody.
Your instincts are right. There are
Call
some
Mike
more
and he'll send you to us.
plaintiff-friendly states, and there are some lesser plaintiff-friendly states.
Don't move to Illinois or Florida.
Yeah, definitely don't practice in Cook County.
That's where I trained.
Is it really? Oh, geez, brutal.
What's that?
Just with like tort reform in certain states,
And
a
it's
lot easier to get docs into the state versus places where it was a little bit more difficult for the doc, they were losing docs.
Right.
because insurance was so sky high because they had ridiculous verdicts, in stupid cases. And so everybody, all the OBs pulled out of West Virginia. I mean, they're like, we're not going. Yeah, I mean, and it didn't pay to take the risk and do it. And so West Virginia was seriously hurting for OBs. People have to come into Ohio or go to Pittsburgh.
Affect us, it affects the people that provide the emergency services.
Right.
So, the neurosurgeon may say, I'll go with this case, I might not be even reimbursed for it, but I can be sued for this very high risk procedure. And the insurance costs for driving people out of West Virginia is a real common example.
Yeah, and that is the biggest example. They couldn't afford the premium, so they just left. And I practice in West Virginia, too. I do Ohio, Kentucky, West Virginia, and Tennessee, so kind of get around.
Well, thank you very, very much.